this meeting to order for the Douglas County Vacation Home Rental Advisory Board. I will start with the Pledge of Allegiance led by Lauren Romaine.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Opening public comment. At this time, public comment will be taken on those items that are within the jurisdiction and control of the Vacation Home Rental Advisory Board. Public comment is limited to 3 minutes per speaker unless additional time is granted by the chairperson. The Vacation Home Rental Advisory Board uses a timer to ensure that everyone has an opportunity to speak. You will see. Lauren will let you know when there's 30 seconds left, and you should start concluding your comments. Once she has let you know your 3 minutes are up, please return to your seat. I haven't been here in months. In addition to opening public comment, closing public comment, and additional public comment periods may be allowed on individual agenda items at the discretion of the chairperson. Is there any opening public comment? This would be things that are not on the agenda, because we'll take public comment during that time. Seeing none, we'll kind of close public comment because I wanted to say something. I wanted to welcome Glenn Wolfson, our new advisory board member. He was just appointed last week by the county commissioners, and we're happy to have you on board. Approval of the agenda. For possible action, approval of the proposed agenda. The Vacation Home Rental Advisory Board reserves the right to take items in a different order, to accomplish business in the most efficient manner, to combine 2 or more agenda items for consideration, and to remove items from the agenda or delay discussion relating to items on the agenda. Today's agenda, we have 1 item that's been withdrawn, item number 3. So I would entertain a motion to approve the agenda with that change.
Madam Chair.
So moved.
Madam Chair, I move we approve the agenda with the exclusion of item 3.
Okay, I'll second.
Any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Thank you. 5-0. Move on to the approval of the previous minutes for possible action. Discussion to approve the draft minutes of the March 22nd, 2023 meeting of the Vacation Home Rental Advisory Board. Before I ask for a motion, I just wanted to ask you, Glenn, if you watched the meeting, you'd probably be comfortable voting. If you did not, you're welcome to abstain. It's entirely up to you. Any comments on the minutes, or I will entertain a motion.
Can I do the Michael Sloan, Lauren Romaine, for the record?
You can do
I do it here? I would just like to say that the minutes are not always completely accurate, and if you really want to know what actually was said and done, it is always good to listen to the video. Is that how we said it? I think that's close. Was that
And
close
then
enough?
he made a motion to
And so I make a motion to approve the minutes.
Okay. Do I have a second?
A second.
Okay. I have a motion and I have a second to approve the minutes. Any further discussion? All those in favor signify by saying aye.
Aye.
Thank you. 5-0. Item number 1 for possible action. Discussion on an appeal filed by Zachary and Callie Shields, owners of 324 Kingsbury Grade, State Line, Nevada, 89449, APN 1318526510010, contesting the denial of an opportunity to apply for a Tier 2 VHR permit due to past non-compliance with the VHR code and the past revocation of their Tier 1 VHR permit at 324 Kingsbury Grade. Mr. Strelo.
Ernie Strelo for the record. On or about December 29th, 2021, appellants Zachary and Callie Shields were issued a Tier 1 VHR permit for the residence located at 324 Kingsbury Grade and State Line. On or about July 19th, 2022, approximately 7 months after the Shields were granted their Tier 1 permit, Douglas County became aware that the advertisements for the property failed to comply with the requirements of the VHR code. Specifically, advertisements on Airbnb listed the entire unit as being available, and they were expressly noted that the owner would not be in the area during stays. These were clear violations, and we cite the code on page 84. Douglas County found and concluded that the property was being rented out in violation of the Tier 1 VHR requirements. Douglas County issued a notice of violation and revoked the Shields Tier 1 VHR permit. In determining to revoke the permit, Douglas County also took notice of the fact that the Shields had previously failed to pay their TOT in a timely manner. The Shields filed an appeal to the VHR Advisory Board, and the hearing was held on September 28, 2022. After a lengthy discussion, the advisory voted unanimously 5-0 to uphold the revocation. The basis for the decision rested on the Shields' failure to review, understand, or follow the VHR code for a period lasting more than 6 months. In addition, another appeal was filed by the Shields to the Board of County Commissioners, and the hearing was held on December 1st, 2022. Again, a lengthy discussion took place, and the Board of County Commissioners voted unanimously 5-0 to uphold the revocation. In July last year, the Shields added their, they did get on the wait list to apply for, to be invited for a Tier 2 permit. On or about February 24th of this year, the county removed the Shields from the wait list and denied them an opportunity to apply for a Tier 2 permit. The basis of the county's decision was the Shields' prior performance as VHR permit holders, which we just read, including their late TOT payments of more than 6 months of violating their Tier 1 VHR permit. In determining whether to issue a VHR permit, Douglas County confirms that the applicant meets requirements set forth in the code, including whether the applicant will comply with all the requirements of this chapter. To achieve this, the county must often examine the prior history of the residents, and it's code cited in the page 85. The county also considers any other information the director or designee deems necessary to administer VHR code 20.622.030 subsection E5. This allows the director and by designation the VHR program manager to fulfill a mandate to carry out the purpose and intent of the code. And the code information is listed on page 85. Shields' prior operation of the VHR has demonstrated inability or unwillingness to comply with the requirements of the VHR code, making them ineligible to receive a VHR permit or apply for a permit. For an extended amount of time, they failed to pay TOT and only began paying TOT after being notified and fined. Similarly, for an extended amount of time, they failed to comply with the requirements of their Tier 1 permit and only sought a Tier 2 approval after being notified that their Tier 1 permit had been revoked. In short, the Shields have shown that they are disinterested in learning or following the requirements of the VHR code and that their compliance with its requirements can only be achieved through enforcement efforts. Such individuals are not qualified to hold a VHR permit. The Shields argue that they can ignore the requirements of the VHR code, have their permit revoked, have the revocation be upheld by 2 separate appellate bodies, and then turn around and reapply for a new permit, as if nothing ever happened. They assert the county is even required to forget the Shields' history of noncompliance. That argument is wildly inconsistent with the purpose and intent of the VHR code. Obtaining a VHR permit is not a right. While the Shields may feel entitled to a Tier 2 permit, there is nothing in the code to support that belief. Their complete indifference to the code regulations demonstrates that they will not comply with the requirements of the VHR code going forward. Therefore, they are not eligible for a permit. There's no reason why they should remain on the application wait list. So the requested action from the county is based on the foregoing, that we request that the VHR Advisory Board affirm the county's decision, uphold the removal of the Shields from the VHR application wait list. Back to you, Madam Chair.
Thank you, Mr. Strelo. Before we hear from you, I want to do a voting on standing. You as in Mr. Shields, since we're on video. Let's start with the findings of whether they have standing. Basically, are they or are they not aggrieved? Conversation about that?
Madam Chair, I move that we find the appellates Zachary and Callie Shields were agreed by the denial of an invite to apply for a Tier 2 VHR permit and have standing appeal.
Okay, thank you. Do I have a second?
Second.
Any more discussion regarding that? Okay, we'll vote on that. All those in favor?
Aye.
5-0 that they do have standing. Now, Mr. Shields, representative.
Good afternoon. My name is Rick Campbell with the law firm of Kemper and Kroll. I'm representing Shields today. Am I limited to 3 minutes, Madam Chair?
No.
Okay, thank you. I want to read what Mr. Stralo said in the BOCC meeting on December 1, 2022 to set this up as to why we're here today. Commissioner Tarkanian in that meeting, and then this was an appeal of your decision the prior summer about revoking his trip permit. Commissioner Tarkanian says, okay, assuming his permit is terminated, Tier 1, with the opportunity to apply for a Tier 2 and be on the waiting list because he had it revoked and he's going to be banned from getting the VHR permit for a certain period of time. Mr. Stralo responds, the waitlist application passed on July 31. He would be eligible to apply for a waitlist on July 1, 2023 through July 31, 2033. And then his application would be judged on the merits. This was told to the county commissioners and as part of the evidence in front of the hearing then. So instead, Mr. Stralo's county development board sends a letter on February 24, 2003 and is not allowing Mr. Shields to even be on the application to apply for a permit. That's the real issue here, is can he apply for the permit? We're not here to determine whether his permit is going to be judged on the merits. That's for a later date. What we're here to say is does the county development or the code ordinance allow Mr. Stralo to deny it even to apply? And the citations in the letter that Mr. Stralo just read and the rebuttal that he submitted to the board earlier just don't hold water. There's several provisions that are cited, and those provisions are not applicable, and they're taken out of context. Mr. Shields actually has a summary of those. If we can hand that out and make that part of the record.
Is that okay to hand it out?
Everything
Yep.
that is given to us needs to be given to the audience as well, under the open meeting laws.
Do you have enough copies?
I have, if you guys want to share, I'll have enough. I think, luckily it's a
Mr.
small
James.
deal.
If there's, yeah, as long as there's enough.
Okay.
Was this in our packet, this
No, this
information?
was in response to the county response. So these were things that, this is just kind of a reference for what.
So it's not something you sent in that's been published?
No.
So I first want to go to the citation to the district, the county commission code 20622-030E51. That's been cited to say that the somehow that's authority for the Mr. Stralo to deny the application. That section is simply stating the requirements, what must be in an application, and does not allow Mr. Stralo or the county to decide whether or not an applicant will comply with the requirements in the future. These are things that are set forth clearly in the application process of the code. This is what you have to apply. It's not what you decide on whether you can even get an application before the board in the first place. The second section that was misquoted was the 20622-030F7. And the statement that Mr. Stralo made is that somehow is authority to pull this, even the ability to apply for this. That section applies to a Tier 3 permit, and it guides the advisory board as to certain issues as to only the Tier 3 permits. We're not talking about a Tier 3 permit. We're not talking about past issues as to whether the Tier 3 permit is applicable here today. So that provision doesn't apply. The next provisions that are cited are again the 622-03050 says, and which states a permit must be issued for the property may be used at a vacation home. Again, at a minimum, all permit applications must contain the following information, any other information the director reasonably deems to administer the chapter. This really states just that the director has the ability to put what is in the VHR permit. It doesn't give the authority to pull Mr. Shields or Mr. Shields' permit from the application process or from the invite process in the first place. Finally, the last code that's cited is 2622-050A. Again, that's not authority to disinvite Mr. Shields from applying for a permit. It grants the authority to direct certain rules and regulations, but we're not talking about the rules and regulations. You can't change the code. The county commission has to change the provisions of the code. The rules and regulations only go to what might be required in the application. So Mr. Shields is not trying to ignore any of the applications. He's trying to comply with this. As you know, in the first place, he wanted to make sure that he had a full hearing on whether or not he made an honest mistake on his application. That was denied. The board upheld that. We understand that. That decision is on appeal now before the district court in Douglas County. So that's not a final decision yet. Mr. Strelo indicated that 2 appeals had already decided that, but it has not been finally decided whether or not he should have been entitled to some kind of a hearing on whether he made an honest mistake in his Tier 1 application. So yeah, we're not trying to dodge anything. What we're really only trying to get here is what Mr. Strelo promised to the board in the board meeting in order for them to make the decision, that he be allowed to file an application to the county for a Tier 2 permit. And that's all that we're asking for at this point. I don't think any of there's no authority that I saw anywhere in the statute that allows the county development director to pull an application based on what he thinks the past indiscretions were from an applicant. Those issues should be decided in the application process itself. Any questions? We're happy to answer them.
Yes, so I want to understand the money involved. When the Shields were placed on the wait list, I assume they did their application to be placed on the wait list?
Yes, whatever application
Did
is to
they
get
pay a
them.
fee to be added to the wait list?
I would assume they would have paid anything that needed to be added to the wait
Okay,
list.
and then, so I'm, because that was critical
Sure.
in some of mine. So they paid a fee, they were placed on the wait list, and then they were removed from the wait list. The permit was never, because Mr. Strelo, I think, knew what he would do if the application was approved, was considered, and so he took them off the wait list. That's correct?
I don't know what he did, but it seems like he put the cart before the horse and made his own decision without seeing the requirements that need to be in an application. Did you watch the Board of County Commissioner meetings when this code was, not the ones now, the original ones? When the original code that you were under now? Back in you mean the revisions in 2020?
Yes.
I actually sued the county on those.
Okay, so did you watch the county commission?
I was in all the hearings personally.
Okay, perfect. Did you see the situation where they had an advisory group who suggested a large number of permits because they were aware of people renting without a permit? And the Board of County Commissioners made a determination that they did not want people who had been operating without a permit to just to have room to get a permit. Do you remember that?
Sure, I remember discussion on that.
Yeah, okay, thank you. Yeah, so and by the way, I think I have an old code, maybe, 2622030, I think you might have done. It says the issuance of a permit is discretionary and not a right? And then back, you also mentioned this in 2622050, because by the way, I absolutely consider your words, because I went through the code today and I found I had the exact same position you had on the Tier 3. Yeah. I thought that would, that was only for Tier 3. So I do watch the words of this. In 2622050, it says the director or designee is authorized and established to establish rules and regulations from time to time as may be required to carry out the purpose and intent of this chapter. And this chapter is on violations and enforcement. So why would you not consider Mr. Strelo's decision to remove someone from the wait list a rule or regulation with the intent of about their previous violations?
Where is that rule or regulation?
I'm not a lawyer, that's why I'm asking a lawyer.
Yeah, there's no such rule or regulation.
It says establish rules and regulations, or do you read that it can't be, it has to be in writing, it has to be published, or is that what you're saying?
I would think so. You have to have notice of things like this. The rules and regulations, I would think, have to be somehow codified in the application process. I don't think it's ultimately the Board of County Commissioners to draft any language into the ordinance. It can't be changed. It can't be changed by Mr. Strelo. Say Mr. Strelo made a suggestion to make some different rules and regulations. If they're going to go into the Board of County Commissioners code, that has to be adopted by the county commissioners.
But A is clear that there are two levels, right? The director may establish rules and regulations, but changes to the ordinance are approved by the Board of County Commissioners. The way I read that as a layman, not an attorney, is that there are rules and regulations which do not go before the county. You can imagine if everything you do and every decision you have on a complexity of something like this has to go before the county commissioners, we would never have any change. I mean, it's a non-ending cycle. But your position would be that for a rule or regulation, it had to have a public. Could you repeat that?
Well, I'm just saying there's nothing in Mr. Stralo's initial letter on February 24th or in the supplement for this hearing that cites any rule or regulation that the Shields violated. Every one of the citations in those two documents is to the Board of County, is to the ordinances. Okay. So what rule or regulation are we talking about?
When the Shields were removed from, I'm sorry, I think we normally just go and I'll stop. When the Shields were removed from the wait list, was there, because their application was never, and I'll give Mr. Strelo an opportunity in a minute when we question him, but when the Shields permit application was not heard, was the fee that they had paid for the permit application returned to them?
As of February 24th, when they were taken off the wait list?
Yes, yeah. So when they were taken off the list, they, and to me, in good faith, applied to be on the list, and they paid a fee for their permit to be reviewed. When they were taken off the list without such a review, was their fee returned?
I don't know. We've immediately appealed that decision to this board right now, so we're hoping that they're able to be back on the wait list and be able to make an application and then have that application decided on the merits.
I'm sorry, Madam Chair, my last question. And so your remedy today, your suggested remedy today, is for us to override Mr. Stralo's decision to remove them from the wait list, put them back on the wait list, and have their permit properly vetted and approved or disapproved.
Their application for a Tier 2 permit to be submitted under the rules and regulations of the county ordinance, and then to be decided on the merits.
Okay, thank you.
That's what we're looking for.
Thank you, Keith. I do have some comments, but I'd like to hear from everybody else. If you have some, Patty or Glenn, do you have anything? No?
No, not right now. But is there a rule that's been made or not published that says that somebody that's had a permit revoked is a lifetime ban and they're not allowed to reapply?
I don't believe that's in code.
Okay.
But Mr. Hames could answer that better.
Yeah, it's AJ Hames from the DA's office for the record. Just to clarify a couple of things. The wait list itself is not in the code. That is, in essence, a procedural regulation that the county has adopted in order to process applications. So just before I get to your question, just to clarify, there's no wait list in code. That's just a procedural tool that's used in order to process applications in an organized manner. And so the process is you get on the wait list, and then at a certain time of year, they look to see which neighborhoods are available, and if the neighborhood has openings, they send you an invite to actually apply. So just to clarify that, because I don't know that was always clear to everybody from the beginning. And then second, with regard to the code and whether people are banned, there's nothing in the code currently that states if you have your permit revoked, then you're banned forever. There is a red line that's being submitted to the Board of County Commissioners that deals with the process for entering some kind of prohibited list, but that hasn't been discussed yet by the county commissioners and it hasn't been approved. So as far as today's purposes go, no, there's nothing in the code that says if you get your permit revoked, you're banned from ever having a permit again.
Any other questions, Glenn?
No.
No?
Thank you.
Okay. Patty, nothing right now?
No, not right now.
Lauren?
I was actually waiting for him to ask the questions of Ernie,
Oh, okay.
because you probably have the same ones.
Then,
But-
if you
Okay.
go to Ernie,
Well,
you ask first.
Then I just wanted to make a couple comments then. Code doesn't cover administrative duties, and that's something we as a new board struggled with, because we would get into the weeds of how Ernie and the staff handle what they handling the administrative duties. So this seems to me that this was an administrative duty, and the director or program manager has broad powers given to them through code to make decisions like this. Now, if you want to ask Ernie his questions.
No,
No, go ahead, go ahead.
Okay, so, Mr. Strelo, you cite, and by the way, so I went through the code similar to council, and some of this I didn't think applied. The tier 3, which was very specific, I did not think applied, but I thought there are some general things that do apply. It is, the issue of a permit is discretionary. Well, discretionary implies discretion. And it doesn't say that's not you, and I think a common reading of this would understand that it is your discretion. Second is that there are rules and regulations, and I don't know if we have a requirement that rules and regulations are written, or it can be the way we start to develop things, the way we start to do things, slowly evolve into those things. But it's directly in violations, and I think that was the reason. They're violations of the TOT tax, and they're violations of the permit. That this section was why you made the determination you did. But I don't understand. So, if there was a permit application, and that permit application was never adjudicated, I don't know what word it is, considered, why would we not return the permit application fee?
Ernie Strelo, for the record, I don't know if we did or didn't.
Okay.
Return the it is $100. It's not a permit fee, it's a waitlist fee. So it's a separate fee. He didn't apply for a permit, he applied to be
I
on the
see.
waitlist. So that was why.
So it's not the 1,000 something, it's 100.
It's $100.
Thank you, sir.
And and for clarification, he was added to the wait list in July of 2022, so I heard 2023 brought up. It was 2022 prior to the Tier 1 appeal, that whole process happening in the fall last year. So he was removed based on 2022. 2023, we don't even know if we're gonna have a wait list this year on 2023. So we haven't gotten to 2023.
And I was just
wait list yet.
I was just reading from the record on
Okay,
that.
did I understand you correctly that he was added to the wait list before the appeals were completed?
He was in the wait list in 2022. So
Okay.
the timeline is on an annual basis. It had been July 1st to July 31st of 2022, 2021. It gets randomized, and then they're put on the wait list that way. Then later in the year, as we start to go through the wait list, and this year we started, I think on December 19th or December 12th, we started working through the wait list. We had 154 on the wait list, and we just kind of chunked through it, about 10 per week, right? So when we got to his name, we had already had the action happen with the Tier 1. So we removed him from that because a couple months prior, he had just had it removed, right? So he was within a very recent scope of violation.
Thank you.
Is that all you have? I have a question about TOT tax. When we heard your appeal, we touched on TOT, but that really wasn't what we were there for. It was about the revocation of your Tier 1. And at the time, you said something to the effect that the penalties and whatnot, they told you not to worry about them, or something like that?
So there's an email string with the outside people that administer the TOT tax. To go back a little bit, and again, I agree with you, that wasn't part of the discussion in your board meeting, nor did the Board of County Commissioners deal on that as part of the revocation process. But what happened was Mr. Shields did not get the notice for some reason on the tax. When he found out about it, he paid the tax. He then started negotiating with the outside entity that collects, that does the fines and penalties. That negotiation took a little while. There was discussion about a potential payment plan, and then we got an email from in 2021, I believe, from that same entity, and his name,
Ryan Jordan.
I got that email in front of me, that he said, let's wait until see what happens with the new ordinance, and then we'll get back to you on what the fines and penalties ultimately will be. And he's never heard back yet.
Okay. Well, that's kind of interesting because TOT has nothing to do with code.
But no,
Yeah, I understand,
different
but
ordinance
Yeah.
he's referencing,
Yeah.
not this one.
The reason I'm asking about it is, we saw a most recent statement, and if in fact it was, don't worry about it, it's going away, I wouldn't think there would be interest payments that are being charged on top of the penalty. So that kind of troubles me that this was touched on prior, and now we're back here again, and that hasn't been resolved.
yeah, and again, it's because he was told to wait and see, never heard back. Again, but I think the real focus on that should be is that when he does, if you decide that he can make an application, then that would be one of the factors in deciding whether or not the application be processed, is on the merits. Did some of those factors as to whether he's complied with the code provisions or done everything necessary. He has a chance to fix that issue now that it's come to the light, and that should be part of the process of the permit application, not this process right now. The process right now should be limited to whether there was authority to pull him off the list, and I don't see anything in the code or any otherwise that would allow him the authority to just pull him off the list. It should be in the application process itself. That's what Mr. Strelo told all the board members in that appeal of your decision earlier on. And part of that was how they made their decision. Now the rug's been pulled out from the shields on that.
With respect, I disagree a little bit because the TOT tax is a completely separate animal. It is something that should have been up to Mr. Shields to be actively working on resolving the issue with or without being on the wait list.
Yeah.
But that said, I think you wanted to say something, so
Yeah,
please
I
go
can.
ahead.
The TOT stuff is really confusing because there was a lot going on. Because there was I received a permit while I was having discussions with Ryan, who was dealing with my TOT case.
And Ryan works for HDL.
He works for HDL, but he also approved my permit, I believe, or at least he was involved in submitting it. So he said, he essentially said, I think you're making a good point here that you had fees and fines that were building for 2 years, and I never got a notification that we owed tax or that there were any fines that were accruing. And so my argument to him was, what if I never knew about this and I was never notified for 20 years and I got a bill for $300,000, and so that's kind of what happened here, except it was just 2 years until it was caught. And so I was just trying to get them to potentially remove some of that, the fines and penalties that were accruing over that 2 years. I never said I wouldn't pay the fines. I paid the tax right away. After that, I never missed a payment. And he said, and it's in one of these emails that we can provide, but he said in that email, he said, once you get your permit and you continue making TOT payments, then the penalties and fees are just going to be there until we decide what to do. And then he referenced a new county law or something that would potentially deal with this issue of having endless accruals of fines. And he specifically said, I think in your case, that would help your payment be much lower. And that's in emails from Ryan.
Yeah.
Thank you.
And again, there's a story that should be part of the record in the application process as to whether that should be a grounds to deny the application itself. Not at this point, I don't think.
Madam Chair, just to be clear, I never considered TOT in this or that. The only reason we discussed TOT, I was trying to figure out how someone made a mistake in understanding the code of Tier 1 versus Tier 2. Because to me, it was relatively clear in the code that there was Tier 2. And so the reason I delved into TOT was to see if they were actively trying to understand how to run a VHR or if they were not. So it never affected my judgment. It was a fact that I was trying to judge veracity of understanding the code and doing an appropriate amount of due diligence about what you're trying to do with the code. That's why it affected me then, and to me it's irrelevant now, except the same thing, that it is a point in time where they had a VHR, actively renting it, and for some reason failed to understand that they owed TOT. It was that fact, not the non-payment was actually irrelevant, except it was just proof they didn't understand they had to pay TOT. Therefore, they had not done much investigation in what it meant to be a permit holder. That was the logic I used about asking about, the TOT. It was not, they didn't pay TOT, that makes them a bad person. It was, were they diligent in understanding the obligations of a permit holder?
Yes, and I think we all looked at that the same way at the time.
Yeah.
I'm just looking at it again because here we are all these months later. Lauren?
So I just have a question, Mr. Strela. So you have discretion to look at, and I was looking for the right verbiage here, past performance, past, what's the right wording there? In order to approve of an application. Is that correct? There's a, that was,
Can I jump in?
yeah.
AJ Hames from the DA's office for the record, and Mr. Campbell can disagree with me, but I think that the legal argument is that the county has not followed the code. The code requires the county to basically ignore the applicants at the waitlist stage and whether or not they may or may not qualify for a permit. To ignore all of that at the waitlist stage, allow them to submit a permit, and then consider those things. And the county's response is, we're not blind. We know who the Shields are. Recall their appeal from a few months ago. We know that ultimately the application will be denied based upon these circumstances, and so we make a determination of ineligibility at the waitlist stage to remove someone from the waitlist so as to not string them along until July. You make the determination early. And so that, I think, is the county's position, and the code, since it does allow the director some discretion in how to manage the program, that the program manager is able to do that. I think that the opposing position is it does not, that in fact the waitlist should be administered just as an administration tool to line up application order, and that determinations as to whether someone should actually get a permit should be made at a later date. And so I think that's kind of the crux of the issue today. Does the program director have the authority to make a predetermination of eligibility at the waitlist stage?
And the interesting part about that is usually a wait list for most things. This is why not everything is written down, because you can't take every circumstance into account, is that a wait list is for someone who's never had a history whatsoever of having a VHR. This is a separate incident with something with different circumstances where there is a prior history and someone's coming on the wait list.
May I address that? And Mr. Hames' comments. I don't think there's anything in writing that says how the wait list is to be administered, or that there's any discretion whatsoever in doing that. What's really troubling, and I just heard, is that there's already been a determination on the merits of an application yet not even submitted yet, not even knowing all the facts of the application, not knowing what the court might do on whether or not Mr. Shields was denied his due process rights of going forward and proving up that he made an honest mistake on the Tier 1 application. How can an applicant know anything about this process if there's some unwritten rules floating around that nobody knows about, that no one cited to? It says, if somehow you have one indiscretion on this case, you're going to be thrown out of even getting on the wait list in the future. I mean, Mr. Ritchie and I did a lot of work on amending that ordinance to make sure that there was provisions in there to protect people, both the residents and the applicants, to make sure that that these things are taken care of. That wasn't in the code, it wasn't codified in the code. Apparently they're trying to resurrect that now, that's fine. That should apply not retroactively to anybody else. But that's not how it is right now. There's nothing in here that says if you have one violation, one, you get thrown out of even being on the wait list in the first place. How does anybody know that if it's never been conveyed? There has to be some kind of notice to people. So again, I would stress that there's just no authority, inherent or otherwise, to pull someone from the wait list. Now apparently just because of the decision they've made that they're not going to get a permit anyway because of what they've done in the past. That seems very, very troubling to me.
I'm thinking about a person that has a tier 2 and their permit's revoked. They have nowhere to go. They can't put themselves on the wait list, I wouldn't think. Your case was more unique because you were, in your opinion, you had another tier to apply for. But as Mr. Hames said, we've already seen the disregard for rules in the past, and it's like I tell my children I don't want to reward bad behavior. So that's kind of what's troubling me on this. Any other comments, questions, Keith?
Well, Madam Chair, the framework I've done in my mind kind of comes back to Mr. Haynes saying the wait list is not here. So the entire wait list is a rule and a regulation that was established for the program. So I don't see what would prevent Mr. Strelo from also making that process, have some kind of vetting process of what he knows, and to save people money who are about to apply for a permit, the time and the money. So, and again, when you go back to the county commission view, there was a clear conversation that when people, that there was some strikes against people who had violations in the past. They specifically said people who hadn't had a permit, they didn't want to give room in the 600 for those permits. That's why the original people said, I think it was 720 was the original suggestion. So
725.
725, because we knew a bunch of people were in violation. They said, no, violations matter. And so I guess I would love to have all these rules, regulations published. I'd like to have all this stuff, but I also know they never will be. And so the same authority that Mr. Strelo has to implement a wait list, which was required because we had a waiting list, because there were more permits in there. The same discretion and the same authority to create a wait list, I think, gives him the same discretion to decide how to administer that wait list. And so it's unfortunate, but I don't see a reason to overturn Mr. Strelo's decision on appeal.
Patty?
Patty Groff for the record. I think there's nothing really in the code that says anything about a wait list for anything. So a lot of my comments that I was going to make are similar to Keith, and I think this is more of administration rather than VHR code, this wait list. And I think Mr. Strelo does have the authority to look at that wait list, investigate it, and see if it's worth the time and energy of both the property owner and the county staff to go further on this. And if there is past history, I think he was in his rights and duties to look at that and consider the decision.
Okay. Any more comments, Glenn?
I understand Mr. Strelo may actually be saving them $1,000 by telling them when it gets to the merits and we decide it's probably not going to be a positive outcome. But I wonder if when you shortchange them the ability to even apply, are they not even allowed to appeal to the Board of County Commissioners to say there is no such thing as a lifetime ban, and perhaps I've learned my lesson and I could be a good neighbor. I was impressed when I read the things that his 3 neighbors I don't think I can get 3 neighbors to come to a meeting and give their time to, support me. So, I mean, I think he is a neighbor and he's part of the community, and I think he's made some mistakes, but I don't know if it rises to the level of the guy that has 40 people at his house and they're feeding the bears, and they deserve a lifetime ban and they shouldn't even bother to apply. I think you probably deserve to have some process, which is documented. It brings to mind, like, you all know Chuck Yeager. He was flying a plane one time, I'm remembering, and a new speed record, and all of a sudden he lost oil pressure, and he had to, get out of the plane by parachute and survived. And the follow-up was simply they found one of his airmen that didn't screw in one of the bolts properly, and he lost the oil pressure, and he destroyed a multi-million-dollar plane. And the commander at the Air Force said, "Don't worry, we've already put that guy in non-plane prep duty. He's never going to see your plane again." And Chuck told the commander, he says, "No, that's the guy that I actually want taking care of my plane before I take off. Because I know he's had so much trouble, he's going to make sure that not only he, but everybody else does the right thing. And I want him there every time." And I think maybe there's a hint of that with this. He's had a lot of trouble. He's a part of the neighborhood, and he should go through the process. And if Mr. Strahler denies him at the time after the proper application, then he and his counsel have a right at that point to at least object to the outcome. I think you're shortchanging him if you don't allow him to apply, and it's his $1,000 to waste.
Okay, thank you, Glenn. I would like to go to public comment unless you have some more comments.
Unless you have any more questions, yeah.
I had some more comments.
Oh, go ahead. Then we'll go to public comment.
I wanted to discuss because I can kind of see where this is going with the discretion. It seems like we're kind of stuck on the discretion part of it. But my argument is, and that logically makes sense, Ernie can use his discretion to implement the ordinance however he sees fit. But if he doesn't, as Glenn said, if he doesn't even give someone the opportunity to apply for something and go through the process and do all the things that the ordinance says, what's to stop? And it's one person. So one person could essentially, and we can't even discuss it because it's his discretion. So what's to stop him from not allowing someone to apply because he just doesn't like them because they're in his neighborhood and he's had fights with them in the past? What's to stop him from making decisions on race or gender? Or, I mean, if we can't talk about it, if it's his discretion and we're not allowed to have a discussion about his appropriate use of his discretion, that seems to me he doesn't just have unfettered discretion to do anything he wants without question. One person. When we have this whole ordinance and this whole community in a VHR advisory board, that just doesn't make sense to me. I also, I'm just going to be honest, I think that based on communications Ernie and Mr. Hames that we've had in the past via email, they didn't go well. They refused to answer some questions that I had. They were just very basic, factual questions about why this was said. I'm confused why Mr. Strahler said to the advisory board, before you had even made a decision, someone asked, what are his chances of getting a permit ever again, any type of permit, if we uphold this revocation? And he said 0. So he knew before you had made a decision and followed the process of the ordinance that he was never going to allow me to have a permit again. And then, when he realized that was incorrect, that's not in the ordinance, because I had mentioned it to him and I had asked him, why did you say this and then this, and he wouldn't answer me, he, in the BOCC meeting, they asked him the same question. They said, because I said, I have a lifetime ban. If you guys uphold this revocation, I have a lifetime ban, because that's what he made us all believe in the advisory board meeting. And he said, no, there's nothing that says he has a lifetime ban. He can submit a tier 2 permit application, and it'll be judged on its merits. So he's contradicted himself. He's said things. He's flip-flopped. Conversations we've had, I just feel like they're a little bit biased, and there is part of the ordinance that you can make an argument that someone is biased against you. And I think based on the things that he said, if that's not bias, I don't know what is. If he said before any decision was made, it wasn't his decision at that point, and he said that he would never give me a permit again. And now he said, well, he can apply, and then when I applied, or tried to apply, he said, you can't apply. And then we're saying, well, he has discretion to do that. It's just like this waterfall of someone is just able to do whatever they want for any reason, and we can't have a discussion about it in here because there's one thing that says he can do what he wants. That just seems kind of short-sighted and ripe for issues and lawsuits down the road because someone else is going to say that they were prejudiced because of this, and then it's going to go to court. And I mean, ours is already being reviewed by a judge. And I think we have a pretty good case that there's bias there based on conversations we've had and all of that, and based on statements that he's made. He was biased. I don't know if that's not bias. I don't know what bias is. And I also want to point out, I pointed this out in the first advisory board meeting during my public comment afterwards, that this whole thing started because I called I believe his name was Daryl. I called him. I asked him to walk me through the process of filling out my application because I was worried I was going to make a mistake because I had the TOT mistake last time. I was trying to do the right thing, and he asked me questions, and I believe that he was correct when he said, is this your primary residence? I said, yeah, it's my primary residence. And he said, okay, tier 1 then. He didn't ask me if I'm there when they are renting. And so there were some assumptions. So there's been numerous occasions of multiple people that work for Douglas County not understanding the ordinance still now. And there's evidence of that even in the argument that they made. They mashed together a bunch of little tiny sentences from different parts of the ordinance to make an argument that wasn't coherent. And that shows that how can everybody get no chance to correct a mistake if the people that are supposed to be the experts on the ordinance can just make repeated mistakes and just put them in writing, put them on the record, give them to you to try to make you make a decision. I mean, I feel like he was either attempting to be dishonest about the parts of the ordinance that he was putting together. I mean, it very clearly says that thing he pulled out applied to a tier 3, and he mashed it up with another comment from another part of the code. He was either doing that or he just doesn't understand the code, but there's no other option. He made a mistake, but it's okay for employees at Douglas County to make mistakes with no consequences. But then when a community member who has a perfect record, neighbors that support him, the whole point of this ordinance is to allow members of the community to enjoy their homes without bothering them, the quiet enjoyment of their homes. That is the most important thing. That is what we do. We've never had a complaint. Our neighbors didn't even know we had an Airbnb. They said, oh, yeah, sure, I mean, great. I'm fine with it. I've never even known you've had one. That's the most important thing, and that's what we've done correctly. And the argument that because I've made a mistake, and that means that I'll continue making them, to Mr. Wolfson's point, I have made 2 very unfortunate mistakes. The first one was very bad timing. My dad died like 2 weeks after I applied for the damn permit, and I just missed it. There was one line. I looked back to see, was there even a notification that said I needed to sign up for a TOT account? Because from my experience with Airbnb, renting Airbnbs, the taxes are always calculated automatically within the Airbnb. So I just didn't even think about it. There was one line in the first email at the very bottom that said, you'll pay your taxes, sign up for an account here. And I just missed it. And I tried to make it right. I offered to pay for the fines. I paid for it. I never missed it again. To me, that's proof that I will continue following the rules, because when I made a mistake, I fixed it promptly. Same thing with this one. I fixed it promptly. I took our ad down. I followed the process. We've been going through this for about 9 months. And there's just been a number of times where I feel like the argument that I'm making is not given equal weight to what the county is making. The whole point of my first appeal to this board was to prove to you that it was an honest mistake. And the ordinance says if it's an honest mistake, I have a chance to correct it. And we got stuck on the whole tier 1 thing because I wasn't going to rent it as a tier 1 when the board was perfectly, had every right to say, we believe it was an honest mistake. Let's just change it on his just make his permit a tier 2, pay the difference of the fees, and that'll be that. And from the reaction to the first one, I mean, I thought that everyone was kind of trying to figure out how I could get a tier 2 permit, or at least it seemed like you believed me. That was my general feeling. I don't want to put words in your mouth or tell you what you believe, but if you did believe me, I should have had a chance to correct it as it says in the ordinance. And it all goes back to this very simple thing where I made a very minor mistake because a Douglas County employee didn't understand the ordinance, and we're still seeing that today. And we're not talking about any of that. We're talking about how one person can just do anything he wants.
Okay, thank you. We'll open up public comment now.
Thank you.
Any public comment? Okay, seeing none.
Madam Chair,
Oh, Mr.
AJ Ames for the record. Before we take or continue with board discussion and maybe entertain a motion, we maybe take like a 5 or 10 minute break.
Yeah.
Sure. So we'll be back at 2:10. What? No, I'm
We're
waiting for them.
received
They have to
first.
look something up.
It's
Because it doesn't say
I
it.
go, I have to give him. I said he has nothing on his record. Maybe you didn't like him.
So let's suppose he applied today, or he's on the wait list
We're going to bring the meeting back to order. Everybody's here, so we have our quorum. I will turn the meeting over to Mr. Hames.
Thank you, Madam Chair. AJ Hames from the DA's office for the record. I appreciate the long break. Apologize for the delay. During the break, I conversed with Mr. Campbell regarding proposed code changes that have been submitted to the Board of County Commissioners for consideration. And if those were to pass, that would have an effect on how this case might be treated, or at least similar cases might be treated in the future. And so the parties have agreed to use that proposal as a basis for a settlement agreement. And so the parties, the county and the Shields at this time have agreed to a continuance to the next advisory board meeting. And so we would just ask that, that the board make a motion to continue this matter to the next regular meeting of the VHR advisory board, and that no further action be taken at this time.
So moved.
Madam Chair, I believe if we do a continuance, we have to state a specific meeting date and time, don't we? Is that not true?
We would.
When we've continued something before, we had to continue it to the meeting to be held on this date at this time in this location. Maybe I'm misremembering that. But if that's the case, I don't care. I don't care if Lauren makes that motion. You know, but I think we need to. Don't we need to be specific, or is that not true? Am I misremembering that?
AJ Hames for the record. That is true in certain circumstances.
We can just
For example, if you have a tier 3 appeal that requires certain noticing, or there's a hearing that requires certain types of mailing and posting, and there's noticing requirements involved. If you're going to continue it on the record, you state the specific date and time and all that. Since this isn't that type of a situation, I don't think that's necessary. We can just continue to the next regular meeting.
Sounds right.
Okay, so I have a motion
Second.
and a second. Okay, that will continue this till the next regular meeting. Any discussion? Seeing none. All those in favor?
Aye.
Thank you. We will go on to item number 2. For possible action, discussion on an appeal filed by Matthew Vance to contest a $20,000 fine relative to a notice of violation, code enforcement case number 23-000075, issued for advertising and or operating an unpermitted vacation home rental at 1262 Lincoln Circle, Zephyr Cove, Nevada 89448, APN 1418341120002. Mr. Strelo.
Ernie Strelo for the record. I hope I say this name right. Cavance?
Yes.
Matthew Cavance is the former holder of a VHR permit. On or about December 10th, 2021, his permit was revoked, and he was instructed to cease all VHR advertising and operations related to his residence at 1262 Lincoln Circle. Though he removed his VHR advertising, Mr. Cavance in the past has continued to operate the property as a VHR on 3 separate occasions, January 14th, March 5th, and March 18th, 2022. Deputies from the DCSO responded to the property and confirmed that the occupants were short-term rentals. For each of these offenses, Mr. Cavance was issued a notice of violation and assessed a fine. Fast forward to at some point in the fall of 2022, Mr. Cavance reposted advertisements for his property on websites like VRBO and Airbnb, sites that are commonly used to advertise short-term rental properties. In November of 2022, the county became aware of the advertisements and also received the complaint that renters were again staying at the property on a short-term basis. The advertisements described the property as being available for 29 night stays. And then there's some examples in here, one of which was dated on 11/9/2022 in Exhibit 1. Mr. Cavance also instructed renters to, quote, contact directly if looking for over 1 week but less than 29 nights, unquote, see Exhibit 1. Additionally, the property was listed with a nightly rate of $700 as opposed to a monthly rate. At $700 per night, 29-night stay would cost $20,300. So that's all in the exhibits. Upon reviewing the updated advertisements, the county became concerned that Mr. Cavance was again attempting to skirt the regulations of the VHR code. The VHR program staff contacted Mr. Cavance and instructed him to remove references to direct bookings for 1 week stays. They also asked that he provide a copy of his most recent rental agreement. This year, in February of 2023, the county received another complaint that rental groups continued to use the property for less than 29 days at a time. Specifically, a neighbor reported that a group of renters arrived on February 18th and left just 7 days later on February 25th. The county reviewed the property advertisements, and we found that not only had Mr. Cavance failed to remove the reference to 1 week stays, he had actually tweaked the wording in a way that made his actions more transparent. And that's listed on page 102 on the top in italics. On or about March 1st, 2023, the county issued Mr. Cavance a notice of violation and assessed him a maximum fine of $20,000 for advertising and or operating a VHR without a permit. In assessing the maximum fine, the county took into account Mr. Cavance's long history of violations, his repeated attempts to get around the constraints of the VHR code, and his refusal to update his advertising, even after being warned by the county in November 2022. And then in response, the vacation home rental is defining the code as a dwelling unit that is rented for the purpose of overnight lodging for a period of not less than 1 day and not more than 28 days. And the code is specified on page 102. Any person who advertises, markets, or operates a vacation home rental located anywhere in Douglas County without a current valid VHR permit is in violation of county code and shall be subject to penalty up to $20,000. It's been noted that Mr. Cavance, it's our feeling he was in clear violation of the VHR code because at various times from November of last year to February this year, he advertised the property as a VHR, stating that it was available for quote unquote 1 week and for a quote minimum 7 days of night use. He did this despite being notified by the county. The $20,000 fine is justified because Mr. Cavance not only advertised the property as a VHR, he also operated it as one. As his February advertisements clearly show, the 29-night booking confirmations were little more than window dressing. Mr. Cavance was renting the property out to people for as little as 1 week at a time, and he was only charging them for 1 week at a time. These facts are supported by the complaints of neighbors who reported visitors coming and going after only 1 week at the property. And I think one of the neighbors is here. Mr. Cavance's own booking confirmations would show people paid rates consistent with short-term stays. You know, and then we just want to note that these are serious violations of county code. What we're requesting is based on the foregoing that the county requested the VHR Advisory Board affirm the county's decision and uphold the imposition of the $20,000 fine. And back to you, Madam Chair.
Thank you, Mr. Strelo. I will look for a motion on standing. That would be on page 86 of your packet.
What page?
86.
Madam Chair, I move we find the appellant Matthew K. Cavance has standing to bring this appeal and is aggrieved by the imposition of a $20,000 fine.
Thank you. A second? Okay, have a motion by Keith and a second by Lauren that Mr. Cavance has standing to bring his appeal and is aggrieved by the imposition of a $20,000 fine. All those in favor? Aye.
Aye.
Thank you. 5-0. Mr. Cavance?
Thank you, Madam Chair, and thank you to the board. I guess I'd like to start off by saying, first, I've never had any direct communication with Mr. Strelo, but I have had communication with Bonnie Harwood in his office on many occasions. Starting at the beginning, regarding the first fine for, I believe it was 2021, beginning of 2021, my permit was revoked very quickly and unexpectedly, and I obviously had bookings on the calendar. I've canceled things that were very long-term, and I've tried to work with renters that had upcoming plans and ask them if they could find other arrangements. This is a very big house. It's mostly 3-generational families that tend to visit the house. They're coming from all over the country and meeting there. I tried my best to simply give them their holiday vacations. It was nothing more than that. I absolutely violated the code. I just felt I had no other choice. It was either screw these people over or, you know, give them a good experience in Douglas County. And I did stop after the fines because honestly, I couldn't afford to. The first fine of $5,000, I still lost money, and I was like, you know what, I can give these people their vacation and still lose money, at least, you know, until the end of the ski season. Once it went to $20,000 and that was approved, I had no choice but to cancel on those people. And it was unfortunate. I just want you to know that this was a very exceptional circumstance and not something that I was doing to purposefully try and skirt county rule or anything else. It was simply trying to be considerate to these families that were coming to Tahoe. That said, I had to cancel all the remaining reservations. Fortunately, most people, you know, by that time had found other alternatives. There's not a whole lot of rentals in April and May that they were able to make other arrangements. As stated, in December, or sorry, I think around sometime in the mid-fall, I decided to try to get rentals for 29 nights or longer. I actually listed it on Zillow as well, so let me make that clear. I've tried to find long-term renters. I've had it on Zillow since that time. I've got it listed. I've had probably 10 to 15 different showings of people that have looked at it for long-term rentals. I've lowered the price trying to get it a long-term rental. I started at $10,000. I have it all the way down to, I had an offer on the table this morning for $7,000 a month. So actually significantly less on a monthly rate than I would get for the rentals of the 29 nights that I'm doing now. Right? So I've been attempting that. It's not that I wouldn't like some long-term renters. And the idea that I am changing my value with the agreements of 29 nights is actually incorrect, right? I'm actually not lowering the price for them. On a month-to-month basis, they'd actually get it. If they were renting for 12 months, they'd actually get it cheaper. So that said, my understanding of the code, right, is that it is for a 29-night rental agreement. The usage of the property is nowhere stated in the code that it must be occupied for the full 29 nights. So in no way have I violated the operation of a short-term rental. The agreements, I've provided all the agreements. I was actually extremely transparent with Ms. Hardwood in December when she called me and asked me about the property. I told her everything. I said, I am looking for 29-night rental contracts only. If the people choose to use it less than that, that is on them. The contracts are not ended early. I do not occupy the property at any other portion if they choose not to be at the property. So the property is simply empty for the duration of that time, should that happen. Of the, I think, 5 or 6 rental agreements that I've gotten over this time, a few of them have opted to stay a little longer than they originally intended. Right? That is their right. They have a rental contract for 29 nights. If they told me they were going to plan to be there for 10 and chose to be there for 29, I legally am obligated to let them use that for 29 nights. Right? It is simply a risk I'm taking on, right, to try and get some income on a monthly basis at this point in time. So my understanding is from the code, that is in compliance. These are 29-night rentals and never less. And never is there a ending of a contract and beginning of a new one within that 29 nights. And I've provided proof of each of those rental agreements. So I don't understand how there is a scenario being proposed where there were 2 groups that somehow occupied my property within a 29-night period, because it is just factually incorrect. So that is the operating side. My even bigger frustration is on the advertisement side. The code is very unclear, right, in terms of what it means to market or advertise, and I understand that there was probably some discretion taken. My frustration is that I was in constant communication with Ms. Hardwood over any issue on my rental. If she contacted me or if I received any notice, I was immediately on the phone with her. I immediately changed what she asked me to. I'm not sure what you were referring to with the change of language, because I don't recall ever changing language between December and February. But again, I was contacted in late February by Ms. Harwood, and she said nothing about the language. She told me, you forgot to remove a permit number that was embedded deep in a description on one of the sites. Immediately took care of it, right? Yet 3 days later, all of a sudden, I get a fine for for advertising short-term rental. I want to comply with it. I've tried to comply with whatever advertising would be appropriate, right? It says in big bold letters at the beginning of both the VRBO and Airbnb app, hey, only available for 9-night rental agreements or more. I don't know how to be any clearer, right, to a prospective tenant, right, than that. I understand that, you know, you cannot auto book on the website for less than 29 nights with me. You can inquire for less than 29 nights. So if somebody went to the website and looked at a 10-night stay, right, it would say, yes, my place is available for those nights, but it still says right there you can't book it for less than 29. It's akin to somebody walking into a grocery store and there are a packet of hot dog buns and there's 10 of them, but they only need 8. It's like telling the store owner, you have to go hide the packages of 10 because that's not what they're interested in right now. Even though you can't pull out 8 of those and go to the register and buy them, right? So that's the backstory on this. Again, I'm not going to read through the document I believe I provided with the appeal that I hope you all were able to see that documentation. But that is the gist of it. I am looking for long-term renters. It's not the preferred method I'd like to go, and I am trying to be 100% compliant as I do this. And I've been 100% transparent with the office as well. So, thank you.
Thank you. Questions for Mr. Kavance?
Mr. Vance, you said you couldn't understand how it could be more obvious, but you could have said 29 nights, $7,000. But because my concern, and I don't know if this is, I'll have to ask Mr. Strelo exactly what page 117 is, so if you want to get to 117, Mr. Strelo. I guess that was my concern because I'm with you a lot of this. You don't force people. I have rented VHRs and did not, I left early, I arrived late, I rented for a week and been there 2 days. So I absolutely understand you can't force people. I'm renting to you, you better live here. I understand that. My concern is, call me about the rates. And by having fluctuating rates, to me, then you're getting into a short-term rental. And I understand your thing that, so if I understand you correctly, there was never one of the rental contracts in the package, unfortunately. If I understood you, your contract says that I'm going to charge you $7, $8, $9, $10,000, whatever you told me you were going to do, but that price goes into the contract. It has nothing less. It says you're renting 29 nights for this amount, right? That is your contract.
That's the Airbnb or VRBO contract. Yes.
Okay, great.
Yes.
So my only concern is making the rate fluctuate because of the number of nights you intend. And I do acknowledge your statement that if someone decided to change their mind and stay there 29, you couldn't limit that. But you also know who you're renting to. And you can dramatically limit that risk of someone actually living there 29 nights because people, you know, if they're coming on vacation with the family, they're not going to be there 30 days, 28 days, right? So you pretty well have a good idea that they're going to be less for that when you do it. And you're setting your rates on that. And I don't know if 117 package, so is 117 where all of a sudden, and on the bottom of 117 is this $700 a night rate, right? It's not a monthly rate, it's a night rate. And I don't know if this is Mr. Strelo, Mrs. Harwood. Yeah, Harwood.
Right, I got that right.
Harwood. I don't know if that's her, Mr. Strelo, or you, but someone's put in here 4/1/23, 4/12/2003, one guest reserve, and it says $700 times 11 nights is $770, a cleaning fee, an Airbnb service fee, total before taxes $9,358. I don't know if the county did that or.
Ernie Strelo for the record. I think there was a comment made that you can't book less than 29 nights, and Bonnie tested it. You can book it for 7 days.
So what this is trying to say
it just sends a request. It does not book it. It sends me a request, and I have to reply and say that is you cannot book those nights.
So I guess in other words, if it says 29, but call me if you want to be here less than 29 days. I can go in here and figure out what my price is going to be for less than 29 days, but then I can't book it. I got to call you and say, hey, I only want it for 11 nights. And are we agreed on the 9,358? Is that all factual?
That is all pretty
Okay,
accurate.
thank
The
you.
one thing I just say, the challenge obviously with Tahoe is the rates vary so much by season, right? And so it does make it a little bit harder. And that's actually more the reason for please call me, please contact me and we can discuss what that monthly amount would be. It's more about the time of year than anything else. And it's hard in Airbnb to adjust them.
Oh, I thought
Because
when I was using it, it had a calendar and every single day.
It does.
When you get 4th of July, you know you found it.
Yeah. But again, I don't want to, it's very difficult because Airbnb is just really not set up well for this.
Yeah, there's no one intended for it.
For obvious reasons. But so let's say they tell me that they want to stay over the 4th of July holiday in July, right? Versus another group says, we just like it for a random week in July, right? I'm well likely to offer the people that want a random week in July a lower rate because they're not going to be staying over that holiday. Again, maybe they're staying from mid-July to mid-August.
So let me make sure I understand this. I sign up for July.
Well, it's not, see, that's just it. It's not July. Like, I don't know if they're going to want, like, mid-July to end of August. I'm not necessarily doing it July 1st to July 31st, right?
Right. But I want 29 days. Mm-hmm. I not only have to tell you I want it for 10 days. I've got to tell you which 10 days. Because if I'm going to be here over 4th of July, you're going to charge me more. I can have the same 29-month period, but I'm going to pay more if I'm here Celebrity Golf Week is right after 4th of July. If I'm here 2 weeks after 4th of July, I'm going to pay less than if I was here at Celebrity Golf Week or 4th of July. So it's not only is it number of nights, it's also variable based on what the impact of that week is.
Impact of that weekend, I might want to use it that weekend, so I might decide, hey, if you really want that, looking for a higher rate. So again, it's not ideal. It obviously causes me more work because I have to tell people, pretty consistently, like, unfortunately, I can't accommodate you, right? And I do that.
Thank you.
Thank you, Joanne.
Any other questions on this yet? Lauren?
And just one more. If they had told me I needed to price it a certain way and that is part of the agreement in terms of it feeling like it was advertised, I'd be happy to have that discussion. Like, it was never really brought up that was an issue when I talked to Ms. Harwood, at least.
So I take it you don't live in Douglas County?
I do not. I live in Vegas.
And, yes, Mr. Strelo?
Ernie Strelo for the record. We don't really tell people how much to charge for anything. I don't care what you charge.
Well, that would have been my understanding, especially based on the code.
The advertisements were pretty clear to her. She has a lot of experience doing this. Mm-hmm. And it was very clear, in addition to the neighbor comments, that you were saying that you're renting for 29 days, but the way your ads are worded and the practice of what you were just explaining indicate that it's not a long term.
Okay. I'd like to know has there been any proof that I have actually had a short-term rental? I don't believe there is any. I have cameras on my property. I have noise monitors on my property. Like, I don't think there could possibly be any proof that I rented to a group for less than 29 days.
Well, Ernie Strelo for the record. So I think that the purpose of the fine was not because of proof that you rented. It was proof of your advertising.
Okay, and I'm not... Right,
so your advertising was confusing. And in the county's view, and based on what we documented in the appendix, you violated
And in my understanding, when I'm contacted by the office and told to correct something and I do it, that should be an understanding that my advertisement is now in compliance. Like, I don't know how I comply. If you call me and tell me to change something, I do it, and then I get fined for it afterwards anyway. It seems just unreasonable, especially when the code is not explicit on exactly what is and is not acceptable from an advertising standpoint.
So when I sell projects, I always end it like, what's your biggest concern? Tell me what your biggest concern is so I can directly address it. So let me tell you my biggest concern. You're renting short term, but only once a month, is my perception. You're renting short term because you never intend, they tell you they're not going to come, you know they're not going to come, you're renting short term, but you've limited yourself to only one rental in a 29 period. And it would be, you understand from the county's perspective how difficult this would ever be to enforce. Because you could have someone this weekend and next weekend, but one is on the tail end of 29 Because I'm assuming when someone calls you, you sit there and figure out which 29 days they're going to rent, because, you know, if I don't have anything in between, I want to put them at the very end of that 29, so as soon as they leave, I can start another rental.
Yeah. I never adjust their contract, but I obviously try to put them towards the beginning.
You move the contracts around to make sure that you could have someone this weekend and next weekend. Your neighbors could complain, hey, short-term rental. Well, no, that's the last 10 days of this 29, and the next one is the first 10 days of that 29.
And I understand that concern, because part of the reason I provided Ms. Harwood in advance of rentals for January, February, and March, I had sent her in advance exactly what the contracts were in December. So I do appreciate that that's a concern. Unfortunately, does that mean I violated code in any way? I don't believe we could point to anything that it does. But I do appreciate the concern of the administration.
Well, and I think I want to point this out. There's a spirit, right? And the spirit of the code is that people who stay in Tahoe 10 days have a different lifestyle than people here 29 days, right? I mean, I am a much different person on vacation than I am when I'm where I live, right? I make more noise. I stay up later. I'm on vacation. And, you know, I completely live differently when I'm on vacation when I'm not. So, you know, I need to ponder everything you've said, because I can see, you know, I had some preconceived things in here, and thank you for clarifying. I was kind of with you. I understood some of this. But realize that from your neighbor's perspective, you've definitely not rented 3 weekends or 2 weeks, I guess 2 weekends, because 10 days is 2 weekends. So you have limited the amount of number of people there, but the people still coming are coming for 10 days. And so those are people, that is a very different tenant than a short-term rental, than a long-term 30-day rental. You get different types of people in the property.
I definitely agree that in most cases that's an accurate statement. Not in all, but in most.
Okay.
And I would also, you know, make it known that, again, in the 3 years or so that I was operating this property, you know, before my permit was revoked due to lots of legal scenarios that we don't need to bring up right now, that the number of complaints of my property were only from one person, and none of those complaints ever was found to be substantiated, not a single time. As I mentioned, I have very tight control on my property when it comes to noise monitoring, video cameras, trash, parking, all of it. So while I appreciate that concern and I understand the spirit, right? The spirit obviously isn't in the code. I'm trying to comply.
Yeah.
It would be very understanding of this committee if they said, we will, you know, rescind this fee, but be understanding that if there are any other problems, any other, you know, issues that are communicated immediately and aren't complied with, that we won't be hearing this again, right? Like that to me would be very fair, given that I have at both points in December and February been extraordinarily responsive to making this, you know, compliant.
My last comment to you is, you know, as I said, I rented 12 of these in Tahoe. And immediately when South Lake Tahoe changed their code, I got an email that said, we can put you together with a group to rent a month. So you tell us we're going to put all this stuff into a database, and we're going to sign one contract with 4 parties, and each of them get a week. Because, you know, they could have a long-term contract. And so I guess my concern is you'll never have enough words on a piece of paper that will prevent the spirit from being violated.
That's fair, and that is a situation that I hope you haven't had to deal with yet. But I can tell you from an Airbnb and VRBO standpoint, that's not legal through their contracts, right? The primary renter must be on site the entire time and with a specific group, and I make that clear as well when these rental agreements are done. So no one, they couldn't change out the parties over that not 29 days. I tell them you can't even change out guests. 2 of you can't stay there for 14 days and have a separate group of friends come in. Like, that's not allowed.
I'm done.
I'm Lauren. Can I?
Yeah, go ahead,
Well,
Lauren.
I mean, for the record, I'm not as eloquent as you are. That's why I like how letting you go first. But I'm just, your whole thing with this, with the type of people that come in. So now you don't go through the fire department stuff anymore. You don't have certain things posted anymore. And you have people coming in on a rotating basis. Yep, not as much because there's a 29-day gap between. It's just, you know, we can't. Someone asked why our ordinance is so confusing and so intricate. It's because amazingly people find ways that can come and critique the fact that the ordinance hasn't written that this is not okay. And I think to the most casual of observers, this is not okay. You are skirting around and you're taking advantage of what we know is the ordinance and what we know is the intent of the ordinance. And this 29-day, okay, so maybe there's not people there as often, but they are on vacation and they don't know where to go and they don't know where to park their car and they're not a 30-day renter. And it just is, we have enough issues with vacation renters that when we have people that are pushing the envelope like this, it makes it bad for all of us. And I just, you know, you have an option. Well, I guess you don't have an option because of where you are with your neighborhood.
Still playing that out.
I can't help that at all.
No, I understand.
But we have an ordinance. It is fairly clear, and when people push them like this, it's just it just makes it bad for all of us here. I just don't see this 29-day thing and playing around with who's there when. There's still part-time renters. They don't know where to go. They need to know where your fire extinguishers are. They need to have a fire person come and inspect, which isn't happening because you don't have a VHR permit anymore. And it's a bridge too far for me.
So I'd argue that I still do have all signs. I still comply with all, and I understand you can't confirm that,
right.
But my argument would be, well, if people come in for 30 days, let's say I was getting people 30 days at a time on these ones, how would that be any different? Like if I had a group coming for 30 days and then the next month a different group coming for 30 days
because
and
then
they were staying.
They then have the time to figure out where your fire extinguisher is versus like they're only there for 5 days. This is why we have a VHR ordinance, because people come and go very quickly. Certain things need to be known by the renters. Certain things need to be available and posted because they come and go very quickly. If you have someone there for a year, think how different that is. They know how fast to drive on the streets. They know where the garbage goes. They know when garbage is. They know how loud they can be or can't be. They are living there, which is a totally different view and what happens with people when they come in for short-term on vacation. And it's just, we're dealing with enough other issues with this that this you know, this skirting around is just, I can't go with it. Yes, I'm sorry.
No, thank you, Lauren.
Yep.
Madam Chair, can I just make a comment?
Of course.
AJ Haynes from the DA's office for the record. I just wanted to clarify, we've been talking about 28 days and 29 days and the purpose of the code. I just wanted to clarify, a VHR is defined in code to be a dwelling unit or a portion of a dwelling unit rented for the purpose of overnight lodging for a period of not less than 1 day and not more than 28 days. So it is in the code that you look at the purpose of the rental. The VHR itself is defined by its purpose. What is the purpose of the rental? If the purpose is to stay between 1 and 28 days, it's a VHR. And that is the definition that we have in our code.
Right, it's not the contract. It's how long they stay.
I'm sorry, Mr. Haynes.
But what happens if I have a, sorry.
Okay, hang on.
It's section 2, the definitions.
Yes.
And it is subsection H, the final definition.
Thank you, sir. Sorry.
I can't control the tenant's purpose. Like, that's just a matter of fact. If they rent it for 29 days, if let's say I put it and you can only rent it for 29 days, and I have no understanding of their purpose, they could show up for 16, right? That's just a matter of fact. I can't control their purpose. As I also said, that if they tell me that they only want to use it for 10 days and show up and stay 29, I have no control over that. They have an agreement, and it is their purpose to have an agreement for 29 and use that.
Lauren?
Yeah, I'm sorry.
No, I'm just
You
saying
do
your
have,
name.
I'm sorry, Lauren Romaine for the record, you do have control over that. You signed a contract for 29 days. You do have that. You're right. You know what? Every once in a while there are good people who rent something for a month and something happens in their family. And that happens. But what you're doing is you're taking this and you're bastardizing it into something that works for you. And I just, it is against what is in code. It is against what is supposed to be allowed. And
I can tell you this is also not something uncommon. I have friends in other areas and cities that have these same types of codes.
two
and
wrongs
this,
don't make a right.
I'm telling you that this is going to be something that you're probably going to deal with other than just me. And all I'm asking for is to rescind the fine and clarify what this needs to be. I will comply with what it needs to be. I'm just not happy about getting hit with a huge fine when it wasn't clear. And I've been talking to the office.
Okay, so the reason for the fine, from my understanding, is because the advertisement makes the appearance that this is a short-term rental. And, you know, we're looking at it right now, and we're seeing what your advertisement says, and it very much appears to circumvent the system.
Can you tell me what you're looking at? Because again, I took the advertisements down as soon as I got the fine.
I'm looking at $700 a night, and the fee if you only stayed 11 nights. And I think there's 2 ads in here that show a nightly rate. And a nightly rate doesn't sound...
The only way to advertise on Airbnb is a nightly rate. I can't do it. There's literally no other way to do it.
Oh, you can't monthly?
No, there's no way to change the calendar to a monthly view. It's non-existent. If I need to change the wording, I'll do it. If I need to change the nightly rate to something that you guys feel is appropriate for a monthly rental, I'll do it based on what I'm trying to get off of Zillow. Again, I am doing what I can to be compliant.
And we're also looking at something where it says minimum 7 nights.
I can remove the minimum 7-night usage and just put, and I'm pretty sure on the most recent advertisement on Airbnb, I had already removed that. That was one of the things I believe I discussed with Bonnie about the Airbnb ad back in December.
And you give Bonnie your schedule of...
I let her know anytime she contacted me, when there was an issue, I said, here are the upcoming contracts, and I emailed them to her and said exactly what those dates were.
Do you let any of your neighbors know?
No, I am not in very good communication with, well, my one neighbor. I've never had any issues with any of my other neighbors in the cul-de-sac.
Lauren Romaine for the record. Wasn't there something where you had, so $700 a night, somebody did the calculations, and that's $20,000 a month, correct? And then one of the contracts was less than that, correct? So you adjust, okay, so you adjust it.
It's yes, less.
I mean, this is what's so obvious. When you adjust...
There's discounts for monthly stays all the time. That's just the thing. If you look on Airbnb and you advertise even if you're advertising seven nights, right? There's a place to put it.
I'm sorry, there shouldn't have to be a discount, because if you are renting for 30 days, then your nightly rate should reflect what your 30-day rate is, because there should not be any adjustment. If you want to know what you need to change, you need to be above board about the fact that every contract is for 30 days.
I'm fine with that.
And whatever the nightly rate is has to be that. I'm
fine with that. And I will be happy to change that. The reason I had it higher is because I was actually getting too many inquiries. Right? And that was not okay. This is not a manageable situation that I want to be in long term. I am trying to find a long-term renter on Zillow, right? As I stated. I would prefer not to be in this situation and have some long-term renters, right? Now, the only reason that it shows higher like that is because if I lower it to $300 a night, I all of a sudden get a ton of inquiries because people,
I'm sorry,
I don't know why.
You're trying to find long-term renters. If you lower the rate, you're going to get renters.
They'll think that because I say contact me it says contact me to discuss pricing. If I put $300 a night and they look and see it's available for 7 nights and it says 29-night contract, they're going to think they can rent it for $2,100. Which I'm not going to do for them because, again, I don't think that's good practice either. I should be doing something that's reasonable for the month. And per Zillow, $7,000 to $12,000 is about what I should be getting on a monthly contract, depending on time of year.
But you adjusted it for the other people.
Which other people?
The contract that was shown. You adjusted it for them.
Down.
Yeah.
Yes. I don't want to give them the impression that a 30-day contract is going to be $200. Like, it's not a good system for me advertising it, which is, again, why I will be happy to comply with whatever you guys decide the right thing to do here is.
So you're not looking for long-term renters as in a a standard 1-year lease.
No, I am. That's what's on Zillow.
You're looking for a
Absolutely.
long-term-
I've had it up there on Zillow since last fall, trying to find long-term. This is a 6-bedroom house. There are not a lot of long-term renters that are looking for six-bedroom houses. Right? Like I said, I've shown it to somewhere between 10 and 15 people. I had a gentleman in my house this morning, right, looking at it, and I've offered him $7,000 to try and get something. Right? This is, I don't know how much more clear I can be that I would love to have a long-term renter.
Do you know, I don't know this answer, so I'm asking you. Do you know what the median rent would be for a house like yours?
Zillow told me anywhere from $9,000 to $12,000 for a house of this size. You know, it takes location and things like that too. I haven't been able to get that.
And would it perhaps make sense to hire a property manager to?
I inquired with 2 different real estate agents in the area, asking them, well, 1, what they would do it for, and 2, will they help me sign it? I can't find a company that's helping me do this.
Okay, well, I'm off base anyway. We're talking about your.
Just to come back to what Lauren's question is, I agree that Airbnb won't facilitate that because Airbnb isn't trying to facilitate this.
Right.
I mean, you look at the ads for Airbnb; they're short-term rentals. They're not for long-term rentals. And so I think that, you know, you're trying to force something through a
Right.
medium which is not intended for that. You're taking advertising. The people who are looking at it are looking for short-term rentals. They're not looking for month to month to month, right? Or even 30 days.
I mean, they do advertise long-term at all, but let's be real, their primary business
Is
is
a short-term, and so that's who you're marketing to
Right.
with Airbnb instead of Zillow as well. And so that's why that's why if I understood you right, you know, I can't get the rate right because they forced me to a nightly rate because that's not the market they're selling into. They're selling into people who expect to be there every single day. And like I said, when I rented, which would be the difference. When I rented something that I wasn't occupying, they still charged me. It wasn't like, well, I'm not occupying, so don't charge me that night. There was a dramatic difference from what I was experiencing what you're experiencing.
And on Airbnb, they do have so basically if you want to offer a discount, they do this for 7 and for 30-day rentals. There's an area you can go in and it says, if you're doing a 30-day rental, would you like to offer a discount? If you had gone in and put in the 30 days, you would have seen the price, because I think I have close to a 50% discount, would have dropped it all the way down to the price that I actually ended up doing the contract with them. So it's just a kludgy system to get there, but if they look at the full range, they actually do see the price for the 30-day rental.
Okay, let's move on to what we're really here for. Patty, do you have any questions or comments?
I have Patty Gruff for the record. I think, you know, originally coming in here and just looking at the paperwork, it looked like you were just trying to circumvent. I understand your position of trying to get someone in there. I think the advertising is just a bad avenue at this point and how it looks.
Optics. Glenn?
I do understand some of the things you're saying about Airbnb, and you can't really price your house at. In fact, once during the pandemic, I had a single, very wealthy lady from San Francisco want to rent my house for 2 months in October and November, which is not really season. And I was happy to move out of my house for basically what I would have gotten for 2 weeks rent in July. So what it would have showed if she had put in 2 months would have been much more than she actually paid me, and she stayed for 2 months while she's still paying on her very expensive place in San Francisco. And I do think, to the uninitiated observer, really, it does look like he's trying to circumvent things. My main question would be, the striking thing to me is it's a $20,000 fine. So I'm asking, are there other things that went into calculating why it's at this level for this offense, besides just that the office determined the advertising was against the code, as in it has something to do with the fact that his permit was revoked, which I don't know about why, and where he had other fines that were given for other violations, and this is a cumulative thing for why they're having to make a point, or is it strictly the wording of the advertising that deemed it to be $20,000?
Would you rather answer this than me?
Sure. AJ Hames for the record, Douglas County DA's office. The code authorizes a fine of up to $20,000 for any advertising or operating of a VHR without a permit. It is the maximum fine. It is a $5,000 lesser fine for individuals who had a permit but through inadvertence or mistake allowed their permit to lapse, but continued advertising. That's not really applicable here. That would be, again, a maximum fine of $5,000. So the maximum is 20. And in this particular scenario, the reason why the county elected to issue the maximum fine was just the history. In this case, Mr. Gavance having previously been assessed a maximum fine, and the fact that he was given a warning in November and had failed to correct the issues with the advertisements.
Thank you.
And
And I'd like to make it clear that that notice, I did correct those in December. It was a mailed notice, not an email. So the day I got the notice, I called the office and talked to Ms. Hart.
Okay. Yeah, I'm going to go to public comment, but go
okay,
ahead.
but Lauren, for the record, just a quick question too, is it, you know, the fines, are they per violation? So where there were short-term rentals happening, are those fines, can they be applied per violation?
Technically, yeah. I don't know that in practice the county's ever done that.
Yeah.
Unless it was a clear subsequent violation. Like if it was a family who had booked a week, I don't think the county's ever gone in and fined the owner of the property for all 7 days.
No, I didn't mean that. I just meant there were like 3 short-term rentals or something, if I remember correctly, and then we've got advertising issues.
They could each be fined. It's a separate offense.
Okay. Is there anything else before we go to public comment? Okay. Thank you, Mr. Gavance. Go ahead.
Yeah.
Public comment.
No one signs your papers now. For the record, Andy Huckbody. I'm the neighbor of Mr. Gavance. And I had submitted public comment, so I'm not going to read that, but just, first of all, I want to thank the board for all their hard work on the revision of the ordinances. You have a tremendous amount of patience to go through this every month. It's really crazy. To be clear, this advertising intent is for short-term rental. And I really warn the county, if you don't handle this, other people, as Matt said, will follow. So your ordinance needs to deal with how people advertise and how they rent. I think we have submitted to the county on the last 3 rentals, the communications between the renters and Mr. Gavance. None of them wanted the property for 29 days. 2 of them wanted it for 7 and 1 wanted it, I think, for 14. He explains to them in their communications, because of the situation of not having a permit, he's got to sign a 29-day agreement. So they come and he, continues to rent without a permit. And as I say, I really strongly suggest that the county doesn't allow that type of rental scheme in the future without jeopardizing the total VHR program. Because all the tier 3s that you turn down and people in the valley, if they're not going to be there for 3 months, now they can do 3 short-term rentals without a problem. And they don't care about your ordinances. So you'll have no enforcement on that. So we are in litigation with the Gavances. We see Judge Young next Tuesday. Because Lake Ridge actually has a deed restriction that requires rentals to be more than 60 days. So he's already documented that's not what he's doing. We're looking to get an injunction because we can't fine like the county. So we hope next week we'll have an injunction against them. And he can rent for 60 days if he wants. Hopefully he can find a long-term rental. We have a lot of long-term rentals in Lake Ridge. You know, the rate, I think, varies from $4,500 to as much as $18,000 a month. So it's, you know, I don't know who he's trying to work with, but there is a need for long-term rentals at the lake, without a question. It's how much people are willing to pay. As he said, he has a very large house, so not everybody wants that, but it's a matter of price, so.
I'm sorry, I didn't give you your 30 seconds.
Okay.
Can I give him?
So I asked the advisory board to see through this rental scheme and deny his appeal. And I thank you for your time.
Thank you. Is there any other public comment on item number 2?
Am I allowed to make any response after public comment? Sorry, I don't know.
No, we're just finished now. Take it back to the board, close public comment. And how would you like to proceed?
Madam Chair, I'm ready to make a motion, and we can discuss it. I have 2 issues. First is setting the price. I think if Mr. Cavance didn't have negotiation and said it's $7,000 regardless, I think he'd have a better position. However, even then, again, talking with Mr. Hames said, I am struck by how the clarity of this. I don't understand the second half, but I do understand the first half. And it says rented for the purpose of overnight lodging for a period not less than 1 day, not more than 28 days. And so when those people sign a contract, regardless that it's 29 days, they are signing for the purpose of renting for 10 days. And he is signing that contract on his side for the purpose of that. They can stay, they can overstay it, and I have to pay more. I admire that, but they are signing, one of the parties at least, are signing for the purpose of renting less than 28 days. Therefore, I believe it is a short-term rental, and therefore I move that we affirm the decision of the county opposing the $20,000 fine issued to Matthew Cavance.
Is there a second?
Or discussion, sorry. I guess we said.
Oh,
Second.
No, second.
And then discuss.
So I have a motion and some seconds. And do we have any discussion? Go ahead.
I agree with everything that's been said, but I would be open to reducing the fine. I think would be reasonable, as I don't imagine there are many $20,000 fines given for non-compliance, and I do think he wants to be compliant in the future, and he already is looking for a long-term renter. And obviously, I'm very new here, but $20,000 to me as a neighbor sounds like a lot of money. I would be open to a lesser fine, because I do think that mistakes were made, and circumstantially it looks intentional. But if the board would consider, or Mr. Strelo would consider lowering the fine, I would certainly be in favor of that. And since he's already paid a $5,000 fine, apparently, if I heard that correctly, I would think double it, and then if something else happened in the future and he was renting again for 29 days for a week, doubling it again to $20,000, and then as the district attorney said, you could actually fine him per violation after that. But I would be uncomfortable my first day here voting for a $20,000 fine for advertising.
May I make just one reminder? Twice this office told me I was in compliance before the fine was sent. Like, I'm not asking the board to allow me to continue to do this, and that's what the board says is allowed. I'm simply asking that you don't fine me for something you told me 2 days prior I was already in compliance with. Like, that's my concern. If you're telling me that this shouldn't be allowed anymore, and that's the new position.
Thank you. Question, AJ, for you. How do I handle Mr. Wolfson's risk?
There's a motion, it's been seconded, so that you can vote on that motion, or if somebody wanted to amend the motion could be amended. One of the motions that you could make would be to, and it's set forth in the agenda, is to modify the county's decision. So you would be, I want to use the right wording.
Well,
I can do that, and maybe it won't get seconded, but I would make a motion to amend it,
Well,
that the
so,
fine would be $10,000.
yeah, as a point of order, there's already a motion, and it's been seconded, and so that is the motion that's being discussed currently. There can't be a conflicting motion until that first motion is
Okay.
resolved.
So we need to vote on this motion.
So unless
Okay.
there is a motion to amend, or there's a motion, that the original motion maker wanted to amend the motion, this would be the time to do it. Otherwise, now would be the time to vote on the original motion, and then if it failed to pass, at that point, you could take a second motion.
No, I will not amend.
What was that?
I will not amend my motion.
You will not amend your motion. Okay, then we will vote on your motion, which is to affirm the decision of the county upholding the $20,000 fine issued to Matthew Cavance. We've had our discussion. All those in favor of upholding the fine, signify by saying aye.
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 Okay, and nay?
Nay.
Okay, so we have a 4-0. Okay, closing public comment. Does anybody have any closing public comment? No? Well then, I
Stay for the
will
fun.
I'm just
Good for you.
adjourn.
Ay, ay, ay.